Okay, well, welcome all. This is our second lunch hour webinar series, Public Charge, Fact and Fiction, hosted by our own Allison Neswood. We have a full hour of content here on the federal rules and what they mean. Again, as the title suggested, separating the facts and fiction. Wanted to say a few words about the organization. I'm Bob Mook, by the way. I'm the Communications Director at Colorado Center on Law and Policy. And at CCLP, our mission is to promote racial well, not our mission. What we generally do is promote racial equity, health, and economic security for Coloradans facing poverty. We recently updated our vision mission statements. We envision a Colorado where everyone has a chance to succeed. And our mission is to stand with diverse communities across Colorado in the fight against poverty through research, legislation, and legal advocacy. We have 4 focus areas that we work on in doing this: food, healthcare, housing, and income. And you can learn more about us if you're not familiar with our work through cclponline.org. Wanted to say a few words about our moderator today, Allison Neswood. She is the Deputy Director of Strategic Priorities for CCLP. We've been very fortunate to have Allison with us on our team for the past 6 years. She asked that I keep her introduction short, but she's got a stellar reputation here in the advocacy community, and I would say impeccable credentials, as you can see from her bio. But I will kind of get out of her way, having teed everything up. We will field some questions at the end, and again, please feel free to make comments or questions anytime during the session, and either Allison will address them during the session or during the Q&A portion. So with that, I'll tee it up to Allison, and enjoy your webinar today.
Thank you, Bob, and thanks to all of you that tuned in. The focus of today's presentation, as Bob said, is public charge, and part of the intention is to help people in a range of disciplines counsel clients regarding public benefit use if those clients might have public charge concerns. So I'm going to talk about, I'll cover the background on public charge rule a little bit. I'll talk about the public charge test under the new rule, and then I'll talk about the public benefit programs that are counted negatively under this new test, as well as some alternative programs that are not covered under the rule. And I am going to cover a lot today, so I might speak a little bit quickly, but I will try to leave some time for questions at the end. And so as quick background, public charge refers to a test that comes up in 2 places. During the legal immigration process. It comes up when someone is applying to enter the United States from abroad, or when someone is applying for adjustment of status. And adjustment of status refers to the process of applying for a green card from inside the United States. And it happens when someone living in the United States with, for example, like a temporary student visa, decides to apply for their green card. In terms of the timeline, public charge has been around, so public charge has been around for a long time. It was adopted at the federal level over 100 years ago in 1882 with advocacy from states like Massachusetts and New York that had used sort of similar policies to turn away and deport migrants fleeing the Irish potato famine. And so the concept is antiquated and actually wasn't playing that much of a role in the immigration process until the current administration came into office. In terms of the timeline for the current rule that we'll be talking about today, after going through the public comment process that's required for passing new regulations in the fall of 2018, Trump's Department of Homeland Security, or DHS, approved a final public charge rule almost a year later in August of 2019. And then implementation of that final rule was delayed due to several court injunctions, but those injunctions were eventually lifted, and the rule went into effect on February 24th, 2020. So the standards that I'm going to talk about today are only effective starting that date going forward. I'll also note that the DHS rule that I just described applies to the U.S. Customs and Immigration Service, or USCIS, and these offices process immigration applications in the United States. This Department of State actually oversees the foreign consulate offices, which process immigration applications abroad in other countries. But the Department of State had started a sort of parallel rulemaking process so that the standards, the public charge standards and self-sufficiency sort of assessment standards I'll be talking about today are in alignment both in the USCIS offices and in the foreign consulate offices, starting again on that February 24th, 2020 date. The Trump administration was interested in this policy from very early on, and his Department of State actually implemented sort of stricter public charge policies for people applying to enter the United States without any rulemaking in February of 2017, right after the administration came into office. So, I say that because just to mention that this policy and these changes have been in the public discourse since, this administration came into office, long before the final rule was implemented. And, going back all the way back to 2017, fear and confusion about the policy have been causing people to disenroll from programs, from government programs, or to forego benefits for which they're eligible. And this is known as the chilling effect. There is data around this. According to a December 2018 nationwide survey, about 1 in 7 adults in immigrant families reported a chilling effect where individuals did not participate in a government program for fear of how it would affect their immigration status. And this is really large impact, given that almost 14% of the US population is foreign born, and 1 in 4 US children has at least one foreign born parent. So the public charge is codified in federal law in the Immigration and Naturalization Act, section 212A4. And under that section, if the government determines that a person is likely to become a public charge in the future, it can deny a person admission to the United States or deny them their green card. The regulations implemented on February 24, 2020 basically redefine public charge. And the definition is briefly stated on the slide as non-citizens who receive one or more of the specified of public benefits specified in the rule for more than 12 cumulative months within any 36-month period. And then under that definition, use of 2 benefits in 1 month counts as 2 benefits. Use of 3 benefits in 1 month counts as 3 months. Then it's cumulative. So even if they didn't all happen at one time, you add them up within a 36-month period. The specified benefits included in that definition are very specific. They're cash assistance programs for income maintenance from any level of government. So it's federal, state, and local programs. The Supplemental Nutrition Assistance Program. This is what's commonly is a federally funded program that's commonly known as food stamps. And then there are certain federal housing programs that are included in that public benefits definition. And then Medicaid is also included, but there are some important exceptions that I'll talk about for those. I'll say right off the bat that there are certain immigrants that are not subject to public charge and would not be affected by these regulations. So in general, so exempt immigrants include people who have refugee status or asylee status, people who have U visas or T visas. These are survivors of trafficking or domestic violence or other serious crimes. Violence Against Women Act self-petitioners, special immigrant juveniles, people with temporary protected status. So this range of groups that are granted status for humanitarian purposes. Also note that public benefits, so any public benefits received while a person is in one of these exempt statuses will not be counted negatively if the person later seeks to adjust to green card status using a non-exempt pathway. In addition, a public charge assessment is not part of the naturalization process, and there's no public charge assessment when green card holders renew their green card. So in general, once somebody has passed the green card stage, or the stage of applying for and being approved for a green card, they're mostly not going to have to worry about the public charge test again, unless they leave for over 6 months and are considered as having abandoned their green card, and then later try to come back and apply for permanent residence again. That'll be counted as a new application. So we do definitely recommend that people who are going to leave for an extended period of time talk with an attorney about how that will affect their status. Now, under the rule, in determining whether an applicant for entry or adjustment of status is likely to become a public charge, the Immigration and Naturalization Act requires immigration officials to review the applicant's current situation and characteristics. So this is referred to as the Totality of Circumstances test, and it requires officials to consider, at a minimum, an immigrant's age, health, family status, income and resources, education and skills, and also the legal sufficiency of an affidavit of support if the person is required to have one. So the affidavit of support is the document that somebody signs if they're going to sponsor, for example, a family member or spouse's green card application. The new regulations add many factors and evidentiary standards to the Totality of Circumstances test and create and weights those factors in different ways. The regulations adopt new income thresholds. So on the negative side, for example, having a household income below 125% of the federal poverty level is a negative factor, unless the household can show that they have significant assets. And 125% of the federal poverty level is listed there. It's about just over $27,000 a year for a family of 3. Other negative factors related to basically the resources or income that a family has available include if the applicant had ever applied for or received any of the public benefit programs specified, so Medicaid, SNAP, federal housing assistance, or cash assistance, if they had applied for or received those benefits in the past, or if the applicant for admission or adjustment of status had applied for a fee waiver for an immigration status application that's subject to public charge. The regulation also assigns negative weight under the test if the applicant has been diagnosed with a serious health condition or conditions that could require extensive treatment in the future, or that could affect their ability to work, attend school, or care for themselves. And in addition, if the applicant has such a condition and can't demonstrate the ability to pay for likely treatment costs or reasonably foreseeable medical expenses, then that factor will be heavily weighted against the applicant for the immigration. Regarding education and skills, the regulations also assign negative weight if the applicant can't demonstrate proficiency in English or can't provide 3 years of tax returns to demonstrate work history. And the regulations also consider education and training and role as a primary caretaker. Finally, I have noted here that the regulations also assign negative weight if the applicant is a child under 18 or is over 55. In terms of positive factors, the regulations assign positive weight if the applicant has a household income at or above 250% of the federal poverty level. So that's, as listed here, about $65,500 a year for a family of 3. And I'll just note that I think the median household income was just over $63,000 in 2018. So with this standard, we're basically saying that people who want to immigrate should have income that's above the median if they want to be favored for immigration on this factor. The positive weight will also be assigned if the applicant has unsubsidized health insurance, and that's unsubsidized by the government. So what it's referring to is like premium tax credits that people get on Connect for Health Colorado to help with the cost of private insurance. It doesn't refer to employer subsidized coverage. So if you do get, or for people who do get an employer subsidized plan, that would count as a positive factor under the rule. And then finally, here at the bottom, I just would assign positive weight if the person is working age, so which it defines as between 18 to 55. The factors that must be considered under the test and how those factors are weighted are in federal regulation at 8 CFR section 212.22B through C, in case anybody wants to write down the citation. As I mentioned, the rule assigns negative weight if someone has applied for or used one of the public benefit programs specified in the rule. And if the applicant for immigration status used a cumulative of 12 months of benefits in the 36-month period before the applicant applied for entry or permanent residence, the negative factor is heavily weighted. As a reminder, the benefit programs specified for negative consideration in the rule are SNAP, certain federal housing programs, cash assistance for income maintenance, and Medicaid, with certain exceptions. And I'm going to say several things about this portion of the rule. First are the Medicaid exceptions. There's some important ones are listed here. They include Medicaid services provided in school. So if a child has an IEP and then Medicaid reimburses the school for some of those services, those services wouldn't be counted negatively under the rule. And then more broadly, Medicaid services used by pregnant women and children are not counted negatively under the rule. And this is important, as I'll explain, due to the way eligibility for Medicaid works, because it's broader for pregnant women and children. And then it also doesn't count negatively use of emergency Medicaid. And this emergency Medicaid is a program that's available to people who would qualify for Medicaid except for their immigration status, and it only pays for treatment of emergency services. Those are the highlights of the main test, but there's some key considerations that I want to lift up. One is that, while there's been a lot of fear around these specific public benefit provisions, immigrants are generally not eligible for Medicaid, SNAP, and federal housing benefits until after they get their green card, meaning they've already passed the public charge test. Refugees and asylees and other humanitarian immigrants are an exception to that. They can get Medicaid benefits as soon as they're granted their status in here and meet the other requirements. But their use of these programs is explicitly exempt in the rule. And then again, lawfully present pregnant women and children can use Medicaid but it wouldn't count against them when they apply for status. And I'll talk a little bit more about the eligibility rules, but basically, pregnant women and children can access Medicaid before they get their green card, but that won't count against them when they apply for their immigration status. In addition, I didn't put it on this slide, but I did want to emphasize that the rules are explicit, that benefits used by children or other family members of people who are applying for immigration status, those benefits used by the family members are not going to count against the person applying for adjustment of status or for their immigration status. So the bottom line is that most people who can qualify for public programs are already past the public charge test or are exempt from the negative implications of the test. The largest exception to this is that many state income maintenance programs have sort of looser eligibility rules. So for example, some allow temporary visa holders to access assistance. And I'll talk about some specific examples in Colorado in a bit. But if users of those programs, use them when they have a temporary work permit and then later apply for their green card, that could create an issue for them or raise a negative factor for them in the test. So now I'm going to switch gears and talk more about public programs in a bit more depth. I'll start with the programs considered under the new or considered for negative treatment under the new public charge rule, and then we'll shift to some alternative programs. First, I'll talk about Medicaid. This program pays for medically necessary healthcare services for people that qualify, including people with disabilities and people who meet certain income requirements. When somebody's eligibility for Medicaid is being assessed, disability status, sometimes pregnancy, citizenship or immigration status, income, and sometimes assets, age, and residency are considered. And the Medicaid eligibility rules for Colorado are at 10 CCR 2505-10, section 8.100.3. Regarding immigration status, the eligibility rules related to immigration status in particular, non-pregnant adults that have had their green card for 5 years can qualify for Medicaid if they meet the other eligibility rules. So there is this 5-year bar for adults who aren't pregnant to qualify for Medicaid. Children and pregnant women aren't subject to that 5-year bar, so they can get Medicaid as soon as they get their green card. They can also qualify as long as they can establish lawful presence. And so it means even if they have a temporary visa, such as a temporary work visa, a pregnant woman could qualify for Medicaid. Refugees, asylees, and people with other statuses granted for humanitarian reasons can also qualify for Medicaid, as I think I mentioned already. And people, and some people who are not citizens or who do not fall in one of the immigration-related eligibility categories that I mentioned can't qualify. They're not eligible to receive Medicaid. So for example, an adult with a temporary work visa or student visa can't qualify for Medicaid unless they're pregnant. And undocumented folks or people with deferred action for childhood arrivals or DACA status, they can't qualify for Medicaid. And I'll talk about some alternative healthcare options, but that's the baseline rule there. Medicaid is critical to the health and well-being of individuals and families dealing with economic insecurity. For people with low incomes, just having health insurance reduces rates of depression, eviction, and bankruptcy. And kids and families with low incomes who have publicly financed coverage are more likely to finish high school, graduate from college, and have a higher income as adults. And so it's really important that the families who need these services are able to access them. It has consequences even outside or beyond health. The Supplemental Nutrition Assistance Program, or SNAP, is a federally funded benefit that provides a monthly food benefit for those that qualify. Whether someone qualifies and the amount of support they receive depends on their household size and the amount of resources the household has available after income and expenses are considered. However, adults that are not disabled and that don't have children may also have to meet work or job training requirements in order to remain eligible. The SNAP eligibility rules for Colorado are at 10 CCR 2506-1, section 4.206. Green card holders can qualify for SNAP once they have had their green card for 5 years. So they're subject to a 5-year bar, and that's for everybody. There's no exception for pregnant women and children. But people granted refugee status, asylum, or those other humanitarian statuses can also qualify for SNAP. Once again, people who don't fall into one of those categories can't qualify for SNAP. They won't be able to be determined eligible. But I will note here that children that meet all the eligibility requirements can qualify for SNAP benefits even if their parents do not qualify due to immigration status or another factor. So this is actually the case for the other public benefit programs discussed. Eligibility for public benefits is really an individual assessment, even though sort of household circumstances like household income are considered in the process. SNAP is also, very critical for the health and well-being of our families. It helps to address food insecurity, obviously, which can be really devastating for people. Food insecurity is associated with higher rates of depression and suicide, and other diseases like diabetes, high blood pressure, heart disease. And it makes it just hard for children to succeed in school and for adults to maintain a job and build a career. With regard to the federal housing programs, the ones that are counted negatively under the rule include federal public housing and Section 8 benefits, so Section 8 vouchers and Section 8 project-based rental assistance. Whether someone qualifies for these programs depends on their household size and household income. Unlike Medicaid and SNAP, which must enroll and provide services to everyone that meets the eligibility requirements, access to federal housing programs is based on availability. So, but despite that, people may be denied because there aren't vouchers available or because there's no services available, but they shouldn't be denied housing based on their immigration status if they're in a status that qualify. And again, green card holders can qualify for housing programs without that 5-year bar. So those programs, that 5-year bar isn't applicable to housing programs. People granted refugee status, asylum status, and those other humanitarian statuses can also qualify for programs. In addition, children that meet all the eligibility requirements can qualify for housing supports like SNAP, even if their parents don't qualify, although the Trump administration is seeking to change this through rule. But for now, in the case of families that include both eligible and ineligible members based on immigration status, sort of prorated rent support benefit is provided so that it only covers sort of the eligible members of the household. I tried to keep links to a minimum on these slides, but the National Immigration Law Center resource linked here provides a really great summary of the range of federal housing programs that are available and the immigrant groups that qualify for those programs, and it has legal citations as well. So, these programs are, of course, about access to housing, and this housing assistance is critical. Even before the pandemic, too many Coloradans were struggling with housing costs as rents were increasing rapidly and wages continue to lag far behind. And housing insecurity makes really every aspect of life harder and has negative impacts on health. These unaffordable rents harm health by, causing families to skip on other needs, like, not buying enough groceries, or not paying, not covering heating or air conditioning costs, or not seeking needed health care. High costs also, or high housing costs also can push families into either unsafe housing conditions or into neighborhoods with fewer resources. And finally, of course, they can cause homelessness, which also endangers health. People who are critically homeless die 30 years earlier than people who are housed. On to income maintenance. So the range of cash assistance programs that are counted negatively under the public charge rule is broader because, as I think I mentioned earlier, federal, state, and local programs are included. For Medicaid and SNAP and housing programs, it's only those ones that receive federal funding. So generally, the rule counts cash assistance for income maintenance. And this refers to programs that are basically designed to maintain people at a certain level of income in an ongoing way. And it generally excludes earned benefits. So programs like Social Security, disability insurance, unemployment insurance, et cetera. The federal programs that do qualify as cash assistance for income maintenance include supplemental security income and the temporary assistance for needy families, which is traditionally the program that's traditionally known as welfare. SSI, the first one I mentioned, is a program for people with disabilities that limit their functional capacity to work or to earn an adequate income that meets their needs. And Colorado's TANF cash grant program is called Colorado Works, and it provides a small monthly benefit to families with very few resources where the parents meet job training requirements. At the state and local government, state and local governments may have income maintenance programs for their residents, separate from the federal programs or federally funded programs. Often they're referred to as general assistance, but we don't have a general assistance program in Colorado. What we do have are programs called Old Age Pension, or OAP, and Aid to the Needy Disabled. And these would both qualify as cash benefit programs that could count negatively under the public charge rule. The former is a program for seniors, OAP is a program for seniors, and A&D is a program for people between 18 to 65 that have mental or physical disabilities that prevent them from working. Green card holders can qualify for SSI and TANF once they've had their green card for 5 years. The 5-year bar is applicable here again. And then people granted refugee status, asylum, or other certain statuses granted for humanitarian purposes can qualify if they meet the other requirements. In addition, families that meet the other eligibility requirements for TANF can receive a child-only benefit if the parents don't qualify due to immigration status. The immigration-related rules for state and local programs are specified in state and local laws and can be broader. In Colorado, OAP and A&D, to the needy disabled, are available to anyone that can, to people that can establish lawful presence as long as they meet the other requirements. And that's a broad classification that includes permanent residents, green card holders, non-immigrants or people with temporary visas, and those with deferred action for childhood arrival status. So this goes back to what I mentioned before, that this is one area where there's a public benefit that's open to people before they get their green card, and then if they later apply for the green card, it could come up in that application process. So before I switch to public programs that aren't included in the public charge rule, I just want to name 3 kind of takeaways from how the public charge rules interact with these rules around public benefits. And first is just to make the point that many non-citizens can qualify for public benefits, even if, including many that don't have to worry about public charge. The second point is that those non-citizens that can qualify for benefits generally don't become eligible for the public programs until after they pass the public charge test, unless they or their use of public benefits is exempt from consideration. And the third is just that, you know, these programs are critical to the health and well-being, and as a result, can be crucial to ensuring that families can maintain their health and financial status. And, you know, those things are also assessed under the public charge rule, regardless of any public benefit use. So that's also an important thing to keep in mind. So while, you know, immigration considerations are really crucial, it's important to realize that counseling people to avoid public programs is not necessarily going to be the safe bet for people. It can cause a lot of harm, and we really need to be talking with families about sort of the range of things that they face as they're making this decision. So there are many public programs that help people meet their needs that are not considered under the new public charge rule. In the area of health, Children's Health Insurance Program, or CHIP plans, including Colorado's Children's Health Plan Plus, or CHIP Plus, are available to children and pregnant women who are just above the income limit for Medicaid. In addition, people can receive reduced cost health insurance plans through Connect for Health Colorado with subsidies under the ACA. People that can establish lawful presence, including permanent residents, non-immigrants, and humanitarian immigrants, can qualify for CHIP and for the reduced price health insurance through Connect for Health Colorado. However, people who are undocumented and people who have DACA status cannot. People may also be able to find resources at individual hospitals or primary care clinics. With regard to hospitals, there's a Colorado Indigent Care Program that serves people who are lawfully present, which includes, in this case, includes DACA. And this CICP program is a program that reduces costs on certain hospital services. Those without legal status, there's the emergency Medicaid program that I mentioned earlier that can pay for some high cost emergency care. And then a lot of hospitals offer financial assistance programs. Finally, there's a large network of community health centers and other primary care clinics across the state that provide discounted primary care services to anyone. They don't they don't make their services restricted based on immigration status at all. And none of those programs that I talked about are considered negatively under the public charge rule, and it's one way that we can work on directing people if they're really resistant to, or they, you know, just don't feel like it's a good idea or the right thing for their families to use Medicaid. With regard to food security, the Supplemental Nutrition Assistance Program for Women, Infants, and Children provides a SNAP-like food benefit for pregnant women and for moms with children, with young children under 5. And also there are free or reduced price school lunch programs, and there are also, you know, emergency food programs like food pantries in communities across the state. None of those programs inquire about immigration status, and none of the food assistance programs, those food assistance programs are counted negatively under the public charge rule. With regard to housing security, there are some housing programs that are not considered negatively under the public charge rule. For example, the Federal Treasury Department administers tax credits for affordable housing programs, such as LIHTC, or the Low Income Housing Tax Credit, which, you know, these finance housing assistance or reduced price housing. In addition, any sort of housing assistance programs funded by state or local governments wouldn't be considered negatively under the public charge rule, nor are programs that help with utilities costs, and those are often, classified or thought of as housing costs, but programs that help with those, like the Low Income Home Energy Assistance Program, or LIHEAP, are not counted negatively under the rule. With regard to cash assistance, there are a range of programs that provide cash, such as programs that provide cash support for domestic violence victims that wouldn't count negatively under the new public charge rule, as they're not for income maintenance. They're not sort of intended to be provided in an ongoing way to maintain the recipient at a certain level of income. The example I gave is more like a cash payment intended to be temporary in response to an emergency. In addition, I alluded to this earlier, but programs like Social Security, disability insurance, unemployment insurance, and the earned income tax credit are not counted negatively, even though they also provide cash, as they're considered sort of earned benefits or benefits tied to employment. And then on this slide, I just have a couple catch-alls, as I'm calling them. The first is that, in general, state and local benefits funded or programs funded at the state or local level are not counted negatively under the public charge test, except for in the case of cash assistance for income maintenance. That's the one area where state and local programs count. But for example, a state like California has a entirely state-funded medical assistance program for people who are undocumented. That program wouldn't count negatively under the public charge rule. In addition, if there's any sort of state-funded food assistance or housing assistance, as I mentioned, those wouldn't count negatively under the rule. And then finally, the last catch-all is, any program that's not Medicaid, SNAP, those federal housing benefits, and cash assistance for income maintenance. There are a lot of programs out there that support our communities in different ways, and this public charge rule doesn't impact those. And I think there was more concern as this rule was being developed and reported in the news, because a much broader range of services was being discussed as being considered for inclusion, like the Affordable Care Act tax credits under the ACA, or even the Earned Income Tax Credit was in an early version, and LIHEAP, the Energy Assistance Program, was in an early version. But those are not in the final version of the rule, and it's very explicit about that. With that, so as I close, I just want to note that there are many programs that exist to meet the needs of people facing economic insecurity. Coloradans are able to apply for many of the Colorado programs at peak.com, and people can find more information about available housing programs at the Colorado Division of Housing or local housing authorities. And if people are uninsured and receive hospital care, we encourage people to ask at the time of service about CICP or about hospital financial assistance programs. And then, with regard to federal income support programs, they're applied for at local Social Security Administration offices. And finally, I just really encourage you, if you haven't done this already, to look for the food assistance and other community support sites, the clinics that are in your area, so you know where to refer clients if they're really in distress or need some assistance to get through hard times. And with that, I think I left a good amount of time for some questions. I don't know if people posted in the chat, but feel free to do so.
Allison, a few people, before we get to the direct Q&As, a few folks ask to clarify on some points that you made throughout the presentation. Marilee Garcia asked if you could repeat the part about a resident being outside the country, then coming back and applying for citizenship. Do you remember that particular point? Can you?
Yeah. And it's not when somebody comes back and applies for citizenship, but I'll back up and say it again. So in general, after somebody receives their green card, that means they've passed the public charge test. And they won't have to do it again when they apply for citizenship. They won't have to do it again when they apply for their green card. But if the green card holder, it's possible that the green card holder could be considered as having abandoned their status. And that happens, for example, when somebody leaves the country with their green card for more than 6 months and then comes back and tries to apply for their green card again. That subsequent green card application is counted like a brand new green card application. The old one doesn't count. And so there is a public charge test that's applied there. And so that's the situation in which, somebody who had been using public benefits as a green card holder would later apply for a green card and then have that public benefit use counted against them.
Great. Jan James asked you to repeat the earned categories that do not count against people.
Sure. So earned benefits, there are actually more, but for example, Social Security disability insurance. This is a federal program that provides a monthly cash benefit to people who can't work because of a disability, but who have who have a work history where they've paid into the Social Security system for enough time that they can get that sort of slightly richer disability benefit, as opposed to like supplemental security income, which provides the benefit just based on disability without that work history.
Okay.
Another one I mentioned, or other ones include like Medicare. You pay Medicare you pay a Medicare premium for your salary with every check, and so when you become a senior, you can qualify for that benefit. It's an earned benefit. And then one more example is just like Social Security retirement. You pay into that over the course of your employment. And then, when you retire, you have that benefit or that income available. Those are different kinds of earned benefits.
Selma asked about unemployment assistance.
Yeah, and unemployment assistance also wouldn't count under the cash assistance for income maintenance. And that one's classified as sort of a benefit connected to work. Unemployment happens when, as we're all like really learning in a much larger way in the current crisis, you lose your job through no fault of your own, but it's actually, unemployment insurance would be like a earned benefit because people pay into that unemployment system as well. But yeah, so it's categorized like those other ones. One like the earned income tax credit is something that's a benefit that's associated with work. And so that is also not counted under the rule.
Robin has a question in the chat that I don't quite understand, but maybe she or you can clarify. It says, would someone with a work social be considered lawfully present?
It depends on the program. So for example, so I talked about Medicaid for pregnant women who are lawfully present, that if the pregnant woman had a work social, then yes, she would count as lawfully present. Same thing with the state programs that look at lawful presence. And so, yeah, in general, for most of the programs, that lawful presence category will qualify somebody as lawfully present, including, I mentioned CICP as well as another program that looks at lawful presence, and subsidies for private insurance that looks at lawful presence. All of those programs would include the work social.
Our colleague Shar said, if you don't have a social security number, one can't get unemployment insurance in Colorado, right? Is it a state option whether people qualify without social security numbers qualify for unemployment insurance?
So that's one where the lawfully present, or where the the immigration eligibility rules for that program don't include people without social security numbers. And like, again, it can get complicated when you're trying to get into the details of these different programs. One overarching recommendation is to apply for the program so that, you know, you can see whether you apply, whether you qualify or not.
Okay, and we have one more in chat. Will an applicant be negatively impacted even if he or she had cancer or other serious illness early on in his or her life, but was able to overcome the illness via medical treatment in their country prior to applying for a green card?
I mean, I think what that person would put into their application is the information that they are, well, first, they wouldn't have a current diagnosis. And so they would, an attorney may be able to help that person understand whether they need to report that at all. If they do need to report that at all, they would be able to sort of provide the documentation that their condition is in remission. But that is really a sort of an important thing in terms of building that case for the individual if they have access to work with an immigration attorney on how to talk about that in the application.
And can you access the questions in Q&A, Allison? You may want to kind of pick through those one by one. I'm still getting some questions through chat.
I'm going to look at this one by Ross. Under the public charge rule, the petitioner's use of public benefits wouldn't make the immigrant's application more likely to be denied on public charge grounds. The requirements for a petitioner are actually different. And in this sort of a specific circumstance, I would really recommend talking with an immigration attorney about how that sponsorship relationship will work. But under the public charge rules, that the petitioner's use of benefits wouldn't make the immigrant's application more likely to be denied for public charge reasons.
Great. Do you want me to go through the Q&As, or would you like to read them and address them? Looks like we have about 7.
I can look at them. So the first one is, why is lack of English proficiency a factor? What is the thinking justification that a person with lower English skills would be more likely to be a public charge? The explanation that's in the rule is that people who don't have English proficiency have a harder time earning a higher income. I think, personally, that this is more based in sort of animosity towards, non-English speakers, immigrants that don't fit a particular race or cultural status. And so, this is one of the factors that was really challenged in comments. A lot of people wrote against it, making the same point, but ultimately the government kept it in, unfortunately. The next question is, do you know if a person goes to ER for COVID and receives public services, but with no insurance, is this considered emergency Medicaid? If the person has an emergency and receives coverage through Medicaid, it would be coverage, under the emergency Medicaid program, including if the emergency were due to COVID-19. And this is an important question. Thank you for answering it, because the federal government did announce that people who seek care for COVID-related reasons would not be considered public charge, would not be penalized under the public charge rule, even if that care was pursued under Medicaid. that was the guidance that was put out from immigration. The next question is, can spouses of immigrants with a temporary status apply to public benefits without it being a negative factor? And the answer to that is, under the rule, the answer is yes. So let's look at an example family. If the father in the family was a temporary worker and the mom had a green card and the child had a green card, if the mom and child qualified for Medicaid and received Medicaid, and then the dad later applied for his green card because he was in a temporary work status, the rule is explicit that the mom and baby's use of Medicaid will not count against the dad. And that's the sort of general rule that's there, that's throughout the rule. I think I answered this one. It was reposted in the chat. So I think I answered that one again. There is a question about sharing the slides. I don't know what we're going to do about that, Bob. Sorry, I'm not up to speed. So I'll let you answer that at the end, but let me see if there are other substantive questions.
We'll post this as a recording on,
okay.
And it will be available on our website and our YouTube channel. But give me a little time. Probably mid next week.
And then Candace asked if we could please show the citation for the COVID-related care guidance you explained. And yes, I can send a link for that. So the next question is, so by coming back, oh, I can respond to that. And then can we get the recording of the webinar? And Bob said that we would work on doing that as fast as possible. And I think that's all that's here. We are at the hour, so I really want to thank everybody again for being involved in the presentation and hearing what you had to say. Thank you.
Thanks so much, everyone, for your questions. Yeah, that was a very stimulating conversation. Just a few more closing words here. Allison, can you switch on the next slide? We do have another slide, right? Okay. So if you do have any other questions offline or things you think about after the session, please email Allison at neswood@cclp.org, and you can learn more about us at CCLP Online. We do have both a Twitter and a Facebook presence, and if you want to start receiving our email alerts, if you're newly familiar with CCLP's work and you want to know more, send me an email at bmook@cclponline.org. So with that, I think, like Allison said, we are at the hour, just running a few minutes late, heading into a long weekend. Hope you all have found this informative, and again, please feel free to circle back if you have any questions. Have a good weekend, and that concludes this session. Thank you.